Good afternoon, Your Honors. The matter before the court is the case entitled In Re JBDBEV Juveniles, case number 25AP033. Representing appellants DB father and ND mother is Carrie Johnson. Appearing with Attorney Johnson is Sharon Gentry. Representing the appellee state of Vermont is Edward Kenny.
Okay, thanks, and good afternoon again, counsel. We'll hear from counsel for the appellant. I understand, Attorney Johnson, you are the only lawyer arguing for the appellant. Is that right?
Yes, Your Honor.
Okay, and if you would please, for the record, start by introducing yourself and identifying your client.
Thank you, and good afternoon. Your Honors, my name is Carrie Johnson. I have the pleasure of representing one of the appellants in this case, DB, the father of the three children who are at the center of the case, and I will be arguing on behalf of both appellants today.
Thank you very much.
The facts in this case are compelling. After losing at merits in December of 2021, the state filed another Chins petition. This second petition repeated allegations that were nearly identical to those contained in the first petition. And those are allegations that a court had already determined were not sufficient to render the children Chins. The sole findings supporting the merits decision with respect to the youngest child, EB, bore no relationship whatsoever to her safety. Thus, there is no evidence supporting the court's conclusion that EB was Chins. The court's merits order urged DCF toward a speedy reunification. Instead, DCF filed for TPR without making any attempts at reunifying the family. Family time coaching hadn't even started at the time that TPR was filed. At TPR, DCF leaned heavily on the merits findings regarding hygiene and the cleanliness of the home, and the court cited these concerns in support of its conclusion that the parents couldn't resume parental duties within a reasonable time. Yet the evidence in the case revealed that DCF had not visited the home since July of 2024, and that visit did not reveal any safety concerns. This is a case where the state had the burden of proving unfitness by clear and convincing evidence, and it offered no evidence showing that at the time of TPR, or even in the many months leading up to it, the home continued to be in an unsafe or unsanitary condition. Less than 2 months after TPR was filed, DJ was placed in a residential treatment program. He's now been in various residential programs for nearly 2 years. And until the court terminated their parental rights, DJ's parents were visiting him every single week. DJ's struggles with obesity, likewise, given his residential placement, cannot be attributed to the parents. The court acknowledged in DJ's case that the first two best interest factors did not favor termination of the parents' rights with respect to DJ. For the third factor, DJ's placement in residential programming, hours away from home, made it impossible for the appellants to attempt to parent him. Thus, there really is no evidence supporting the court's conclusion with respect to DJ that the parents couldn't resume parenting within a reasonable time. The court's findings in support of its conclusion that the parents did not play a constructive role in their children's lives, including the allegations that the parents engaged in future talk and that they didn't bring healthy snacks to visits, are without evidentiary support. The TPR robbed DJ of consistent weekly contact with his family and also likely with any chance at permanency. On behalf of both of the appellants, I would respectfully request that this honorable court reverse the merits and TPR with respect to all three of the children, and I'll reserve any remaining time for rebuttal.
Okay, thank you very much. We'll turn to counsel for the appellee. Please, for the record, introduce yourself, identify your client, and then proceed.
Thank you, Your Honor. Your Honor, my name is Edward Kenny. I'm an Assistant Attorney General representing the state of Vermont and DCF in particular. Your Honor, the court should affirm the family division's Chins and TPR decisions. Both decisions were grounded in factual findings based on admissible evidence and applied the correct legal criteria. In some appellant's brief and argument, essentially asked this court to reweigh evidence that the court had before it and weighed appropriately and exercised its discretion in making its findings and conclusions of law. A number of things. First of all, the family courts are allowed to consider treatment of other children's other siblings in determining chins. Just wanted to bring that out. There are a couple of legal issues that were raised that I'd like to address. First of all, one of the arguments against the court's decision is that it combined the temporary care hearing and the Chins merits hearing. The law allows this. It was the proper thing to do. The law also requires timely adjudication of juvenile cases, and given the timing in this case, if the court had gone for a temporary care hearing and delayed the Chins merits hearing, that would have delayed the case considerably. So it is allowed to do that, and it's cited in our brief. Would also add that the court specifically acknowledged when making its Chins finding and temporary care findings, it specifically acknowledged not only the different evidentiary standards that were at play, but the court also acknowledged the different facts that were relevant regarding each of the three children. There's no evidence that this led to any kind of error that would warrant reversal, for that matter, any error at all. A number of other things that are in appellant's brief. The court did admonish against lengthy objections, but the appellants don't cite any moment where that caused substantial harm or a difference in the way the case was presented or its resolution. I would note that the court only one time in a 5-day hearing said that it made a decision on an objection based on the fact that its admonition to make short objections wasn't complied with. And Your Honors, I would also point out that if you read the rest of that transcript, as I've done, it turns out that the attorneys actually disregard the court's admonition anyway. They continue to make speaking objections. They continue to say objection and say why, and the court continues to, I don't know if banter would be the right word, but continues to entertain their objections. The Chins merits facts would have to be, this court's going to uphold those unless they're clearly erroneous. They're not clearly erroneous. There's no indication that they would be. There were 2 points that I wanted to bring out that were in appellant's brief. One is that the appellants argue, a father argues, that no evidence offered at merits supported the court's finding that the children were morbidly obese. That's actually in the transcripts of December 12, 2022 at page 94. That is testimony offered by the oldest child's therapist, who specifically said exactly that. Secondly, the appellant argues that the children were, that the finding that the children were absent from school 25 times was based on unreliable hearsay. Also, I point the court to the transcripts of December 19th, 2022, pages 174 through 191. The school attendance records were actually admitted through the testimony of the school principal. As non-hearsay.
You have 1 minute, counsel.
Thank you.
You have 1 minute.
Thank you. They were admitted as non-hearsay business records. In fact, the father's attorney voir dired the witness on the foundational issues and made no objection. Your Honors, the termination of parental rights in this case was supported by sufficient amounts of evidence, and the findings that the court made were based on that evidence. Those findings informed the court's application of law, and there's no specific finding that is clearly erroneous. And therefore would lead to an overturning of this case. It's my presentation. If there's any questions, obviously I'd entertain them, but other than that, I'm completed my presentation, and I thank you.
All right, thank you very much. How much time does the appellant have, please?
Appellant has 51 seconds remaining.
Counsel?
Thank you, Your Honor. With respect to the treatment of siblings, as I explained in my reply brief, that's a fact-specific determination that needs to be, you need to establish a risk of harm with respect to all the children. And I don't think I found a single case where the treatment of siblings rule was applied when the only allegations were neglect. It's primarily applied in physical abuse cases. The issue with combining merits and temporary care is that a significant amount of hearsay came in to that proceeding and prejudiced the merits findings. The attendance records.
Excuse me, do you have an example of that from the record where the court or from the court's order where it used hearsay to rule on merits when it should have only used it for temporary care?
I think the admission of the attendance records is one such example, actually, Your Honor. The attendance records were not reliable. I'd argue that they're not actually a business record because of how they're created. The testimony was that the child has to be in the if the child's not in the classroom, I think by 8 a.m., then they're marked absent. And there was also an issue about whether tardies were being double counted as absences. So 3 tardies equals 1 absence. And the principal was unable to explain whether there were absences listed that weren't actually absences, but were just the result of the kids perhaps being less than 5 minutes late to class or not actually making it to their classroom by that 8 a.m. cutoff.
Okay, all right, your time has expired. Thank you. Please call a conclusion of the hearing.
That concludes today's hearings.
Thank you both.